So what qualifies for DUI? Drunk driving or driving under the influence. It can be either under the influence of alcohol, which usually means your blood alcohol level is above a 0.08%, or sometimes drugs, and that could be unlawful drugs or prescription drugs that affect your ability to drive safely. The law technically defines impairment as not being able to drive your car with the caution characteristic of a sober person under the same circumstances. So we have two different types of DUI in California. One is what we call the per se, and that is if your blood alcohol level is tested within 3 hours after driving stops and you're a 0.08% or higher, you're guilty of the B count, 23152B. The other kind is based on impairment under Section A, and that's where you can't operate your vehicle under the caution characteristic of a sober person under the same or similar circumstance. So the blood alcohol limits are different depending on how old you are and what your job is. So commercial drivers can't drive with a 0.04 or higher blood alcohol level. Adults can't drive with a 0.08% or higher blood alcohol level. Minors can't drive with any alcohol in their system. So if they register a 0.01% or higher, they're breaking the law. So we get questions about whether you can be charged with a DUI even if your blood alcohol level is below a 0.08%. The simple answer is yes. It usually comes up where there's some alcohol in your system and a combination of drugs, or occasionally when you have a prescription or non-prescription drug that by itself impairs your ability to drive a car safely. So what drugs can get you charged with DUI? And the answer is basically anything that impairs your ability to drive safely. It doesn't matter if it's over-the-counter allergy medication that you take too many of, or whether it's a prescribed drug that you've taken for years. Anything that impairs your ability to drive safely, whether legal, over-the-counter, or illegal, can get you a DUI arrest. So how does California treat marijuana DUIs? Because California recently made legal, almost completely legal marijuana for recreational use, we see a lot more of it now. California says that you are DUI impaired for the purposes of marijuana if you can't drive safely based on the marijuana use. The hard part for the prosecution is it's very hard to test the level of THC in your actual system for the purposes of their proof.
David Lear Law, StrongestDefense.com.